Well, hello and welcome. My name is Kubeir. Welcome to the channel. Welcome to the Sunday morning session, another episode where we bring you something so detailed, something so interesting with regards to Canadian immigration, your application, the processes, the updates. I have with me today a very revered guest, somebody who's an expert, somebody who can tell you much more than me and obviously lots of other people out there who can guide you, who can basically explain to you in detail what you can do with your applications when you are facing problems, concerns, delays, etc., etc., etc. So before I start wasting more of your time and keep that guest waiting, let me bring him on. Welcome, Lev. Welcome to the channel.
Thank you, Kubeir. Thank you for that fantastic introduction. Excited
Well,
to be here.
I haven't even started introducing you, but I would not take that from you. Why don't you introduce yourself, Lev? Go ahead.
Yeah, thank you. So I'm an immigration lawyer. I've been called to the bar in 2012. Been doing this for close to 10 years now. I'm a partner at a boutique firm downtown Toronto, and my practice is primarily focused on immigration litigation. So federal court, tribunal work, refugee work, etc.
Well, that's a lot of work, right? I mean, a lot of immigration, a lot of processes, and a lot of those that the dangerous stuff that most of us would like to say, federal court and litigation and all that. But does every application have to go through litigation, or does it go to litigation at all?
No, not every application has to go through litigation, and you certainly want to avoid litigation. But my approach is to prepare applications to a JR standard, if you will. So if your application is rejected, you have a good chance of success at the federal court, as well as possibly just negotiating a settlement with the DOJ, with the Department of Justice directly. So then you're not waiting for a hearing, you're not waiting for a decision, you have a strong case, etc.
Okay. So just to clarify, anybody can handle their own immigration application. They don't need me as a consultant. They don't need you as a lawyer. It's only when it gets troublesome. It's only when it gets into the problem areas where they should usually come and consult a professional who can guide them through the way. That's where you come in, correct?
Right. So I mostly come in when there are issues. However, I do also prepare applications, and I often work on complex files, and I often tell my clients we may end up at federal court. So we're going to spend a lot more time than perhaps somebody else would on your application. We're going to prepare it to a high standard, and we're going to make sure that when we go to court, if we have to get there, we're going to have a good chance of success. And sometimes, by the way, it takes a couple of tries. I've had cases which I litigated for 3 years, 4 years, complex cases. There's one judicial review. There's another judicial review where I'm asking for a directed verdict, etc. Negotiated the settlement with instructions to the next officer and so on. So you do need a lawyer to go to federal court. That's your question. We also do recommend at the very least having a consultant or a lawyer review your application, because occasionally we see issues that really could have been addressed just by way of a letter or an additional document that sometimes lead to a rejection or a delay.
Interesting. Yeah. So basically, just for the audience as well, listen, if you guys are dealing with an application, that's fine. And if you think, so first thing you need to understand, a consultant is different than a lawyer. A lawyer by itself, because they have appeared in front of a bar, they've passed the bar exam, and they are now, so they basically have an accreditation from the law society, whether provincial or federal. No, there is no federal law society. I'm getting that wrong, right?
There's no federal law society. So they're provincial law societies. And yes, lawyers are members of provincial bars, highly regulated exams, ethic courses, very high licensing fees, yearly CPDs, and so on. And I think consultants are subject to some same checklines.
Yeah. Okay. So that's the biggest difference in terms of the regulatory authority as well. Consultants obviously are not members of any of the law society. Consultants are member of their regulator, which is CICC, College of Immigration and Citizenship Consultants. Lawyers are members of their provincial law societies and obviously held to some very serious standards in terms of the regulations. Only lawyers can represent a client in the federal court. Consultants cannot do that. Consultants cannot even advise you in any matters where you have to be referred to in a situation where you have to go to the court. So always have that differentiation clear in your mind. But away from the technicality, Lev, what's happening with IRCC? I mean, I'm sure you have already been seeing so many cases. You've handled so many cases where applications have been delayed. what is happening with the backlogs? I mean, it's a mess. You know it, I know it. I mean, I know you deal with litigation primarily, but this backlogs over the last 2 years under the pretext of COVID, under the pretext of Afghanistan, I mean, the delays that they face there, and then the Ukraine issues, and then earlier Hong Kong. What's going on with IRCC? Why are all these backlogs still there?
Yeah, so backlogs are in the news, right? But I think what's not in the news is the real causes of those backlogs, which in my mind stem from an archaic structure, operational issues, mismanagement, and a general sort of reliance on a structure that is really from the 1960s or the 1950s, right? Which is now unable to function and unable to deal with something like COVID, with the issues brought about by COVID, which are not, by the way, a justification for this. I often tell my clients this, like, if you build a ship with a rudder that is poorly placed and where there are holes at certain areas and so on, it encounters some weather and it drowns. What caused the ship to drown? Is it the weather? Is it COVID? Or is it the fact that the ship was very poorly constructed and so on? So we're seeing huge backlogs, and I think that there's a lot of frustration on there, not just because of the backlogs, but because of lack of clarity, lack of transparency. People have placed their faith in Canada. They have, in some cases, sold their homes. They're ready to go. They are foregoing employment opportunities. IRCC kept saying 6 months is sufficient, 6 months is sufficient, express entry is supposed to be express and quick. Yet we've seen files that were pending for 50-something months, right? Way prior to COVID. So this mismanagement, if you will, goes ways back. The backlogs are significant. Now we can talk about what constitutes a backlog, whether or a delay, whether it's just an application that is pending or whether when it's pending over a certain amount of time. But in my view, IRCC is functioning very poorly. And what we've been doing is taking IRCC to court and filing what is referred to as a Writ of Mandamus, and essentially directing their attention to an application and getting that application moving and getting that application approved.
Okay. Now, before I jump into the more complex matters of the Writ of Mandamus and similar, I mean, wouldn't you wonder that IRCC, being IRCC and such a huge federal department, wouldn't they have got their act together by now, considering they've had more than 2 years of this pandemic?
No, they have not. And that's the problem. The pandemic really just highlighted systemic issues. Why are files that are filed within the same visa office under the same stream processed in completely different timelines? You can see a file from Accra, Ghana, for example, in something like 17 months in FSW. You can see one for 33 months without review required, by the way. Why is that? Why is the UK, at least prior to the Ukrainian crisis, why were they able to process applications fairly quickly? And why is New Delhi taking over a year to process a work permit? Imagine that, waiting for a year to get your worker, or maybe an owner-operator. So no, IRCC has not gotten their act together. In part, this also has to do with political issues, right? They've prioritized targets, in my view, over pending applications, right? And there's this politicization, which I think is quite unhealthy. And there's been a lack of debate as to how the structure should actually be changed. Because why are we relying on visa offices in 2020? What's the use of that? Why don't we have a centralized system that processes applications, first in, first serve, it's digital, and so on? When you go to a bank to get a mortgage application approved, they're not telling you, hey, Kubeir, we're working on 2020 right now. Sorry, can't buy a house right now, Come back. Yeah. Your property bill surprisingly came on time, right? Imagine going somewhere and they say, hey, we're currently sorting mail from 2019 because of COVID, right? It's an excuse. That's all it is. And I hope that what will come out of this are systemic, fundamental changes, not just throwing money at the problem, changing the way the system structures.
Well, that's interesting. But I mean, Sean Fraser, the new immigration minister, not so new anymore. He sounds like a pretty reasonable guy. Do you really think as an immigration minister, you have that much of leeway versus IRCC at the department? Because the department stays the same. The most of the senior management, the think tank within the operations department of IRCC, they remain the same. The immigration ministers will change as and when the portfolios change. So do you think as a minister, he is going to have a bigger or a different impact on the way IRCC is dealing with these issues? Because he obviously at least is coming out and communicating with people, which Marco Mendicino didn't do. So what's your thoughts on that?
So I like Sean Fraser, but me liking him personally has, like you suggested, has little to do with whether the system is going to change. I think a few things have to happen. So we right now, I'm hoping that I'm working with the reporter who I'm hoping is going to do more of an investigative piece behind some of the systemic issues, right? There has to be a standing committee. There has to be an examination of structural issues within IRCC. Like, how did we arrive here? Everything else functions, and we're dealing with electronic applications. We're not dealing with supply chain issues. It's not as if IRCC is dealing with a chip shortage, it's, this material didn't come from China or India or whatever. And no, it's an electronic application, And what I'm hoping is going to happen is there's going to be more public debate. There's going to be more scrutiny. People are going to stop accepting COVID as an excuse. Oh, COVID, of course. Yeah, that makes sense.
We should have stopped that long back.
And then perhaps we're going to see systemic changes. We're going to see transparency, right? A lot of people are saying, that's fine. I can maybe wait, but tell me when so I can plan my life. Is it going to be 50 months, 40 months, 30 months? And so on. So I'm hoping there's going to be more public discussion. I'm hoping there's going to be more pressure. There are going to be parliamentary or sort of committees that are structured to address some of the issues. And then I'm hoping we'll see change. Like there's a saying, do not let a good crisis go away without change, right? Whether it's in your personal life, whether it's in business, something has happened. Well, let's see what has caused it. We have not had that conversation.
Sean Fraser was there for the recent CBA conference. He was there for the recent NCIC, which was National Conference of Immigration Consultants as well. And in both the conferences, he came out and said the same thing, which was that the fact that they are moving towards making things better by three ways: policies, technology, and what was it? Obviously, a lot of influence of money going in there as well. And at the end of the day, it would have to sort of take some will and intent at that level for them to make those systematic changes as you're talking about. But instead of getting into that, let's get into the more meatier subject that's the reason we are here. And that is, what should a person do if they are facing increasing amount of delay in processing of their applications? So with that, I know we're going to talk about the Writ of Mandamus. So let's start with, what is Writ of Mandamus? What does it mean? What does it do? And what should one do to get into it?
Let's take a step back. First of all, there are different types of applications. So we've helped with citizenship files, permanent residency, temporary residency. Some of them are in family class, some of them are economic. Some of them are maybe the most egregious ones, protected persons filing for permanent residency. Those were taking 2 years even before COVID. Why? Nobody knows. Pretty shameful in my mind. So first, understand where you stand. And if there is an issue with your application, try to address it preemptively. So we recommend ordering CMS notes if you suspect some concern, understanding perhaps where the application is at, if there are any concerns, and so on. We also recommend submitting a case-specific inquiry, asking for the application to be processed. Generally, those don't work, but this is one of the prerequisites for Writ of Mandamus, a prior demand. Now, if you're frustrated and if you're prepared to take IRCC to court, we recommend exploring the Writ of Mandamus. What is a Writ of Mandamus? It's not a demand letter to IRCC. This is a judicial remedy whereby you take IRCC to court asking for an order, directing IRCC to issue a decision with respect to a pending application. I know that we're asking for a decision. You're not asking for a positive decision, just a decision. Now, in some cases, we'll ask for what is referred to as a directive verdict, i.e. that IRCC issues a particular decision. But generally speaking, what happens after you file the writ is IRCC's attention is immediately diverted to a particular application, and they action it. And as we all know, an application can be processed with a few clicks of a button. So in most of our files, we see the application being actioned, maybe an ADR being issued, maybe a medical being extended, maybe a medical being requested, etc., and then an approval. And the practical effects, I would say, of a mandamus right now are perhaps more important than the legal test that I can go over. But just to summarize, again, the Writ of Mandamus is a judicial remedy whereby you're asking a higher court, the federal court, to order an administrative body, IRCC, to do something. In this case, to issue a decision. So that's an introduction to the Writ of Mandamus, if you will.
So you're saying if you were to file for a writ of mandamus, then the application goes to the court for the court to decide that IRCC should take a decision on the application. Doesn't have to be negative or positive, that the IRCC is forced to take a decision. Do all the applications actually go to a phase where a judge has to make a decision on that?
Well, that's the interesting part. So prior to COVID-19, I approached the Writ of Mandamus as something that is holier than thou, where really we have to hone down on the delay, contextualize it, and really be prepared to take the matter to a hearing. I was telling people, hey, maybe it's not time yet, etc. I explain how serious it is and so on. And it is a serious issue. It is an extraordinary remedy. But what we're seeing now is the fact that the Writ of Mandamus forces IRCC first and foremost to pay attention to the application. Imagine you have 65 files on your desk or 1,000 files, right? And you gain conflicted instructions. Hey, Kubeir, prioritize this file. Hey, Kubeir, actually, we're going to change things around. Hey, here's the new software or whatever. And you're confused, right? All of a sudden, somebody calls you from higher up and says, hey, what about that file? You're like, oh, I'm going to pay attention to it. Next thing you know, you click a few buttons. Actually, this guy's ready to go. And the application is miraculously approved. So it's just attention. So far, I can tell you, we've done about 200 of those. Now, not everyone is perfected and so on.
200?
200. And there are other lawyers doing this, by the way. Like, this is, we pride ourselves on the quality of work. I'm passionate about this. Sometimes I take cases pro bono and so on. I'm here not to be loved by RCC and so on, or even the DOJ. I'm here to do a job for you. I believe that RCC has, frankly, been shameful in its approach to immigrants and so on. And this whole COVID nonsense, excuses, generic responses, right? I'm here to try to get your applications approved and to make sure that procedurally and substantively your rights are protected. But in any event, historically, when we started filing these applications, stage one, issuance of the notes of application was typically sufficient. Not just us, we've seen this with other lawyers. Now, stage two, perfection, whereby you file an application record with the court, which sets out the relevant evidence and so on, as well as our legal submissions, is becoming more common. And I have to know that until an application is perfected, the notice of application is more like a threat, like, hey, I'm here. Once it's perfected, there's a proper legal proceeding, to which the Department of Justice, acting for RCC, has to respond. Now, quite often, instead of getting a response from the Department of Justice, we get an approval, we get the application action. Sometimes the DOJ will reach out and say, hey, Lev, let's put this on hold for 30 days so that my client can process it and so on. So we're seeing great results. I know how technical you want this discussion to be. I can go into some of the technical.
No. On the contrary, I was going to sort of ask you, let's not be technical at all. Technical, you and I can obviously discuss it off the camera, but for the audience here, I'm going to ask you absolutely the ground basic rule. I'm thinking that I do not know anything about what is DOJ, what is mandamus, what is application. So I am a client, all right? So let's play this out. I'm your client. Okay. Let's do this a mock. I'm a client. Hey, Lev, hi, my name is Kubeir. I have an application which I have got nothing from IRCC. I have my GCMS notes. It says everything is passed. My eligibility is passed. Everything is passed. And I'm not hearing anything from them. 2 years have passed. What can I do?
Yeah. So firstly, that processing time does play an important part. Now, it's a part of the legal test, if you will. There has to be an unreasonable delay. What is an unreasonable delay? And here I will address RCC's new approach to processing times that they introduced on March 31st, whereby they're now giving you dynamic processing time with respect to PR and citizenship applications.
Yeah.
Now, those processing times tell us nothing about how long it should actually take to process an application.
Sure.
For example, if it takes me a year to hang some shelves around my apartment, that has nothing to do with the complexity of hanging those shelves. I could be doing other things, etc. How long should it take to process something? So let's say you're a federal skilled worker, you're outside of Canada, our most common application. When Express Entry was introduced, Kenney, who was the minister at the time, so Jason Kenney, the Honorable Jason Kenney, said Canada deserves a 21st century processing system, right? 21st century,
Yeah.
fast, economic needs, etc. Applications are going to take 6 months because they don't need to take more than 6 months. Everything is digital, everything is online, everything's going to be fantastic, right? So what happened? Why is it taking 30 months? So first of all, there has to be an unreasonable delay. Now, in my view, anything over 15 months on an express entry application, that is routine, where you have not misrepresented in the past and were banned for 5 years, or you have, an adoption that is not fully supported, or some other issues, right? Health issues. In my mind, that becomes unreasonable. I'm willing to give IRCC a few months for COVID, like all of us. We set up a remote system, or we already had one. We sort of, reinforced it, if you will. But in my mind, anything over 15 months is unreasonable. I'm not going to suggest that 27 months is how long it should take. So if you come to me and say, I've been waiting for 20 months, I will ask you, all right. So firstly, how important is this delay to you? If you say, Lev, I don't care. I'm loving my life in India. I'm prepared to wait another 2 to 3 years. I'm really not stressed. I'm so fine, you can wait. If you tell me, hey, I'm a young software engineer, I cannot in good conscience negotiate my next career steps. I'm looking to start a family. My in-laws are putting pressure on me, and I don't know whether I should start it here or there because, okay, fair enough. So it is important to you. The delay is unreasonable. Next, have you previously requested IRCC to process the application? Have you written to them and said, hey, what's going on? Status update, etc. Case will suggest that this is sufficient. If you have done that, we recommend proceeding with the Writ of Mandamus. If the ratio between the payment, so to speak, and the delay is there for you. For some people, it may be no, I'm prepared to wait. Other people say, hey, Lev, like we charge roughly $4,200 for the perfection first stage. You're like, no problem. I'm not even going to wait. Like we do a few procedural. I don't want to wait anymore. I want certainty, etc., etc. I want to start my life, right? And then what we'll do is we'll file a notice of application with the court. Depending on what route you want to take, will either indicate that reasons have been received or have not been received. We can talk about that. And that starts the process. A lot of information. So if you want to break it down,
I'm going to sort of quiz you a bit on that because yes, that was a lot of information. So backtracking a bit, I come to you and I say, okay, Lev, I want to do something about my application, which is delayed for 20 months or 2 years now. So the first step is obviously you're going to ask me a few questions. So I need to have made a demand to IRCC. That's probably the first step. Would you say?
First, very important step. And you have to, if you tell me, hey, Lev, my GCMS notes say that there are concerns about my offer of employment being fraudulent, or there are concerns about my employment records matching the NOC. Say, Kubeir, do not file a mandamus. Hire someone to review your application, supplement it, make sure the evidence is attached to the file, and we do this occasionally for some people. And then once you're ready to proceed, we'll file a mandamus, because the mandamus is likely to work. But what we will get in a case like that, with, let's say, serious concerns about employment records, you'll get a decision. It's going to be a negative decision, right? So you don't want that. So you want to make sure your application is in a position to be approved. Important. Okay. There's a prior demand for performance. So if you write a web form, say, please process my application, that's important. The delay is up to us. We argue that delay in the notes of application as well as in our submissions. And I've spoken to the DOJ when they come back to me on occasion. Hey, Lev, 27 months have not passed. Like, Daniel, let me ask you this. What should take longer, a Toronto condo or an electronic application? We both know this has nothing to do with COVID. And then sort of they apologize. Sometimes they reach out to their client and they get the file moving that way. Anyhow, I digress. So the rest is in our hands.
All right. Okay. Again, sort of backtracking a bit in the sense like, so I come to you and I tell you that my application, I have got the GCMS notes. Everything is cleared. It was apparently passed, or it said RFV, ready for visa, long time back. My eligibility is passed. What's going on? So can I go with you for a writ of mandamus in this case? So the first step would be to ask, or rather to sort of say that was a demand made to IRCC in terms of giving a decision. That's the first step, correct?
That's the first step, yes. So,
and obviously, I also need to have a reasonable reason. I have to have a reason where the delay is affecting my life, correct? There's a
okay. So that's okay. So we can talk about the legal. So again, a couple of things. I'll run you through the legal test. No problem. I do know that right now, and this may sound a bit strange, the practical effects of the writ of mandamus, in my mind, are more important than the legal test. I occasionally have clients, because everybody's anxious, obviously it's a big thing, they've launched or they're thinking of launching, and they file a case from 1867 where, Lord so-and-so says a mandamus is this, or from 2005 or what if RCC, practical effects that we've seen, that other lawyers have seen, is that it focuses RCC's attention, a few clicks of the button, the application is moving, and then it's approved. Now, the legal test, if you want to talk about that, it's not terribly complex. The key aspects of the test are there has to be a public duty owed to the applicant. So in this case, that is not an issue because you've submitted an application pursuant to, in this case, an invitation, there's a program, etc. There's a clear right to the performance of the duty. So this is an important part. If you've submitted an application where you're not meeting program requirements, etc., where you've complicated life, etc., you may not have a clear right to the performance. 99% of cases, that's not an issue. There's no other adequate remedy. In most cases, that's clear. And the last part is the balance of convenience, whether the balance of convenience favors granting the writ. What is the balance of convenience? It's essentially an assessment of whether it is, from policy considerations or big picture considerations, better for the court to allow RCC to continue delaying, even though the delay is unreasonable, or whether the effect on the applicant is greater than the potential disruption to RCC. And sorry, I forgot the most basic, obviously, part of the test, which is there must be an unreasonable delay, and the applicant is not responsible for that delay. So,
okay, but the legal test, I'm sorry to sort of stop you there a bit, Lev, but the legal test gets into the more technical side of things, right?
Okay.
As an applicant who probably will never ever
let me interrupt you. Just three things you got to think about. Okay. Prior demand for performance, unreasonable delay, you're somehow affected by that delay. That's it. Like I will boil it down for you. You don't need to think about all of the
give me those three things again. So I sort of
prior demand for performance, an unreasonable delay that you did not cause, and your life is affected by the delay. So somehow you're affected in a negative manner, right? It may be you cannot take the next career step, you cannot buy a home, you cannot start a family, whatever. You're separated from your family. We've done spousals where people have not seen each other for years.
All right. So I will, again, for the audience, sum it up again. Three main conditions. Prior demand has to be made to IRCC. Listen, guys, I've been waiting for such a long time. I need to get a decision. Prior demand. There has been an unreasonable delay. So the standard processing times, as we understand from IRCC, from the time it was initiated, was about 6 months for an express entry application. However, if you're a spousal sponsorship application, 12 months is the standard processing time. Or for
Let me talk about processing time. Just so you can summarize the test. I will address what is unreasonable.
Okay, all right. So the unreasonable delay has happened, which you would consider at least three times more than the standard processing time, whatever that is. And the third one basically is that you are facing hardship, or this has affected your life personally in a manner which would be considered as a hardship, or which would be considered as you not being able to continue with your life in the normal. These three main criteria for you to sort of go on.
Perfect. So you summed it up great. So the unreasonable delay, this is where things get interesting. What is an unreasonable delay? Well, IRCC is currently saying it's 27 months for an FSW. I've only waited for 21. I shouldn't file a writ of mandamus because I haven't waited. The current processing time simply tells you how backlogged and how poorly IRCC is functioning. It may go from 27 months to 28 months, to 80 months, to 90 months, to at some point before you pass, right? So the question before the court is not how long it's currently taking, but has sufficient time elapsed to allow IRCC to process an application? What is reasonable here in terms of taking this type of an application and processing it? Now, we know that historically 6 months have always been deemed reasonable. In fact, until March 31st, 2022, IRCC continued saying it will take 6 months, right? So 6 months we know is a reasonable framework. Next, you're waiting for 20-something months, let's say. Okay, can IRCC explain the delay? Can they come back and say, well, COVID has, led to mass hospitalization of our workers, and thereby we couldn't process application? That would be a reasonable explanation. They cannot come back with anything except generic disruptions and so on. So if they cannot explain the delay, 6 months is what we maintain as reasonable. We can give them a few months on account of, disruptions, etc. Every lawyer is different. In my view, we take files from express entry that are 15 months or more. Why should we allow IRCC to be insulated from real world requirements, right? I was having a discussion about this with my fiance, who's also a lawyer, and I was thinking, maybe we're too aggressive. Right? It's just, no, why are you creating excuses for IRCC? She worked as a securities lawyer with the OSC here and so on. When they submit an application to list a company, they get feedback within a couple of weeks, right? Bam, 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 analyst and so on. A mortgage shop, why are we going to say that, and so on? So we argue that the delay is unreasonable based on how long it should take to process it, because IRCC cannot provide any sort of cogent explanation. The last part is the balance of convenience. So I hope that sort of explains things.
Yeah, no, I get that.
Criteria on spousals and so on, but we're not going to rely on how long it's currently taking.
All right,
because it could be 80 months. We can go back to 2012 FSW. What is it? 7 years? Oh, so should I wait for 7 years and a year to file? No, that's crazy.
Right. Got that. So unreasonable period of processing time, understood that. Got the fact of unreasonable, or rather the hardship on your life, got that. And obviously the fact that you made a demand. 3 main criteria. Now, I come to you, I ask you to do this, I pay your fee. And from there on, how much time do you think it will now take? Or not do you think, but how much time do you guys have an experience into saying that the day you finally perfected your application and you submitted, you've perfected the whole argument and sent it to the DOJ, from that date onwards, how much time?
Okay, so I know you don't want to make this too technical, but I have to just talk about one more technical issue, so bear with me.
Okay.
Your audience, I'm sure, is very knowledgeable, and they may have heard about this. So once you file the notes of application, or when you're preparing that first document, the notes of application sets out the grounds for what you're seeking, the writ of mandamus. It sets out the relief you're seeking, so the writ of mandamus, etc. We ask for costs plus the grounds. The notes of application is a templated thing and is normally designed to deal with a visa rejection. It's just a template from the federal court, right? They create a template so that every applicant will use the same template. Now, that template says you must indicate whether reasons have been received or they have not been received. As you know, what are reasons? The officer's notes, right? So let's say you prepared a fantastic application, the officer spilled coffee in it, didn't understand it, rejected it. You hired me to challenge it. I say reasons have not been received. The federal court registered and orders IRCC to produce the reasons, the notes. By the way, very archaic. Why aren't you getting the reasons right away? But here's the important part. If we indicate that the reasons have been received, we can proceed straight to perfection, and that will change timelines a bit. If we indicate that reasons have not been received, IRCC is going to produce a letter which says the application is still pending, and then you have 30 days to perfect. Why am I telling you this? Because those timelines will vary a bit. Now, generally speaking, most files are in the 30 to 60-day range after we commence proceedings. That's sort of average. Some files take 10, 15 days. When we started, it was really quick. Now more people are doing it. Perfection is becoming more important. In some cases,
30 to 60 days to what? I mean, so 30 to 60 days to get a decision.
On average, if we sort of have to average it out, right? We take some exceptional cases and so on. Generally, within 30 to 60 days, people get a request for a passport or they get this ECOPR and so on. Now, there are ebbs and flows. Sometimes, when we started 10, 15 days, then it took longer and it took shorter. We have one file that may get to the leave stage, right? A New Brunswick entrepreneur who has already invested in the province. Imagine this. He's having to sue the government for his right to create Canadian jobs. To me, that's just insane, right? Like, why is he paying me to help Canada to invest? In any event, he may get to the leave stage, right? We've seen files where we perfect, IRCC comes back by way of the DOJ and says, hey, there's an investigation at the provincial stage, right? So at the very least, the client knows there's investigation. So his application's been on hold, right? So some of those files are taking longer, right? I have a client right now banned from MISRA for 5 years. IRCC has not moved on that particular file. I've spoken to the DOJ and so on. As you probably know, people who have been banned from MISRA Canada is sometimes makes things difficult for them. So I'm taking some of those files that tend longer out. And we also have to think about how long, if you're doing the no reasons route, how long are you waiting for that no reasons letter? So a lot of technicalities, hope we can parse them through.
Yeah, no, I mean, I understand the technicalities. I'm not sure how many of the audience is getting it. First of all, for everybody who's listening, DOJ stands for Department of Justice. All right. So again, tell me in very, very simple terms, Lev, I come to you, I give you the application. We agree about the 3 factors which will lead me to file this writ of mandamus. And I say, okay, let's go for it. We pay your fee, we sign the retainer with you, and we move on with this. From that day onwards, once you start the proceedings, you are saying on an average 30 to 60 days in a normal or a reasonable
in a normal case, historically speaking, a normal case, I'm taking work permits here, I'm taking spousals, I'm taking citizenship files. So citizenship files generally don't go to perfection. I'm averaging it out, right?
Okay.
So in that period, you're likely going to you're at the very least likely going to get some sort of movement. You'll see a ghost update. You may get an ADR, and then you're likely going to see an approval within that period of time. Now, I have to keep this in mind. I cannot guarantee this to you. I'm simply relaying past results. Secondly, let's say your file for some reason has not moved. That is really, in a way, I mean, it's unfortunate, but in a way, the closer you get to, let's say, the leave stage, the more pressure there is on the DOJ. If leave is granted, the closer you get to the hearing. Why would IRCC want a hearing on a stupid, file that they messed up, forgot about, and so on? So it still puts pressure to finalize. Now, again, we've not had a single hearing. We may get one leave decision, so very few files even make it to that stage. And by the way, leave will take maybe 3 to 4 months from the time the DOJ responds and so on. So we've seen excellent results. I think they're a function of focusing IRCC's attention onto a file. Worst case scenario, you get to a hearing, which unfortunately will probably take 10 to 12 months from the time you started the process.
Wow.
Let's say you get there. Worst case scenario. The delay now is far greater. It's easier for me to argue your file, et cetera, right? I'm hoping that we don't get there. My job is to help you and so on. But I cannot guarantee it. All I can relate is sort of the results we've seen. Most of our clients are referrals. I've sort of lived some of those experiences with my clients where, one client said that it didn't sink in because he's been waiting for a long time, ONP investigation, this and that. So it's like just paralyzed tears of joy and so on. And I'm sort of, I haven't gone through what he has gone through, but I'm sort of feeling, that because it becomes surreal for people in any event.
No, I understand. All right. So let me just move this away because I know it's getting a lot of technical jargon for a lot of people out there. They're trying to figure out what is the leave. They're trying to figure out the trial. They're trying to figure out what is perfecting an application. They're trying to figure out notice of application. So very, very simply, again, one more time, just to summarize and break it down. So 3 conditions, which we have discussed about, come to you, you proceed. It will take between 30 to 60 days. In most cases where everything is reasonably met and it's all clear, you'll get a threat. From 30 to 60 days, you will get a decision. God forbid it goes to the stage of leave. It could take about 4 to 6 months. And if it goes to a trial, if at all, I mean, fingers crossed there. I don't think anybody should go to that for a hearing. Sorry, not a trial. It can't be a trial here. It has to be for a hearing. It could go up to 12 months. That would be the generic timelines. I don't think most of
those would be the generic timelines. Now, some files will probably end up at the hearing eventually. Why? Because IRCC is stuck on some issue, right? Like at the end of the day, I cannot control them and so on. I know that the process works based on our experience. The retention is focused. I cannot explain for the life of me, for example, why this New Brunswick entrepreneur, or I don't know if I think he's New Brunswick, but why is it getting to the leave stage? Like, why isn't it being prioritized? I've noticed that paper-based applications sometimes will take longer with a mandamus, right? I've noticed that citizenship files, for example, we file the notice of application, we get pretty quick results. I noticed that in spousals, we generally perfect because I think it takes IRCC just more time to process them. So files are a bit different. Just keep that in mind.
All right, got that. Okay, so is this okay? I know you're a lawyer. I know this is something which you do for a living. I do immigration applications for a living, and obviously at the same time, we would still go out and tell people that immigration applications you can do yourself. When they get complicated, try to go to a professional. In your opinion, do you think writ of mandamus is a practical approach or a reasonable approach to sort of get a decision, or can people just sort of wait it out? Because at the end of the day, it's going to still cost you money, right?
Yeah, I mean, it depends on what your priorities are. So I'm interested in policy. I'm interested in more than just making money and so on. And I enjoy helping people. But in a normal world, people should not be paying me to get their applications approved. Like it's obscene. Why should families have to pay me to get IRCC to do its job? So I'm hoping, which is what we talked about, that there's going to be real systemic changes. And I think the backlog will eventually be clear. But there's some cases, maybe there's a security issue and they forgot about it. Maybe there's a review required concern. And I think those folks are unfortunately going to benefit from a mandamus in the long term as well. In the short term, they are working on the backlogs, etc. The question is, because of this sort of mismanagement and poor functioning, is your file going to be approved in 20 months, 27 months, 40 months? Like I've seen an FSW that took 54 months. So that's my concern if I'm a client. I don't quite know. It's a balance between time and money. Are you willing to wait, etc.? So it's hard for me to give you a definitive answer. I will say this: if you have the means, to me, it's a no-brainer. If the means are, if there's a balance between a mandamus and paying rent or feeding your family, whatever, obviously do that. We're not doing that. So and they are working on the backlog. It's just, will your file be approached in a reasonable manner? Will it not? And that's the problem that IRCC created with this. We approved this application, but not that one, even though they're identical, and people get nervous. They're trying to understand what they're working on and so on. So I know it's not a direct answer, but it's the best I can tell you.
Okay, then in that case, can an applicant themselves file a writ of mandamus?
Well, there's nothing stopping them from trying to do so. I would say that when it comes to the perfection stage, having a professional helps. It's something that we're trained to do. So my practice is focused on immigration litigation, for example. Generally speaking, lawyers who go to court are more focused on this, have a deeper understanding, and so on. So I would recommend hiring a lawyer. You can maybe try filing the notes of application yourself, but what if you need to perfect? What are you going to do? And maybe it becomes sort of complicated. I would recommend hiring a lawyer, but obviously there's also a bit of a bias on my part, in terms of like, you probably recommend that people hire you.
No, I'm just asking that question to understand that. Can an individual, let's say
an individual can be self-represented. If they want to go to court on their own, they can.
They can, right? So that's the point I'm getting at. For example, it could be a lawyer who's practicing in a different country, so they understand the law. They can do a research in trying to figure out what is needed as per the Canadian immigration law is concerned. So can that individual do their own writ of mandamus?
There's nothing stopping them from. I would recommend hiring or consulting with a professional. From a technical perspective, there's no rule or law that says you must hire a lawyer to proceed with seeking a writ of mandamus in the federal court.
Okay, great. Now, I come from India, and I'm sure you have a lot of Indian clients as well. Now, we, again, historically, we are a bit intimidated by administration. So by administration, I mean government authorities, because we have this feeling, or we are scared that if you try to go against the government authority in a lot of cases, I'm not saying now, but historically, then they can hold it against you. So for example, at the end of the day, there are people on the other side who can basically get this to be an ego tussle. Like, how dare you file a complaint against me? Can IRCC take it against you, or rather hold it against you, that how dare you go and file a writ of mandamus against us?
So this is the most common question we get. I come from the former Soviet Union. I was born in Russia. So I very much understand those concerns. And not only Indian people have that. So I was putting together some of my former clients with a CBC reporter. And an Australian national tells me, I will do the interview, but only if my real name is not used, because I don't want this to affect my citizenship application. He's not Indian, but he's been so traumatized by IRCC that he thinks, he's become paranoid. So to answer your question very clearly, IRCC will not punish you for taking them to federal court. I have right now a client, not a mandamus client, although we had a mandamus for him at one point. I think we had 3 judicial reviews in total. Very complicated case. Finally, he's been reunited with his family. He's about to become a citizen. So just a small example, but no, RCC does not punish you. And we understand that this sort of mismatch in power, this all-powerful RCC, here I am like an applicant, and I'm trying to tell them something.
Yeah.
So no, the answer is no, RCC will not punish you. Canada is a country where the rule of law is supreme on the whole, and you have this right, and you should exercise your right without fear. Say that. You should not file writs of mandamus previously, etc., but you have the right to do so, and if you can, then go ahead and do it.
Okay, all right. That sort of puts me at ease as well, because how administration, and I mean, you said you understand that quite well as well.
I understand
But in a lot of cases, nothing to do with writ of mandamus or nothing to do with delays. For example, you file a JR, judicial review, for people who don't understand JR. If you file a JR for a study permit application, let's say an individual study permit application was refused, you have filed a judicial review, and the federal court has approved your leave and has now made a decision that it should go back to IRCC for a reconsideration by a different officer. Now, the different officer understands that this has come back from the federal court. It basically means that one of his or her colleagues was the one who made the initial decision. Does IRCC sort of keep a checkbook that this person's decision was challenged in the federal court and it was granted leave, or this person's application was dismissed? Do they have some sort of a checkbook or a scorecard to say, okay, these visa officers, their usual decisions or a lot of their decisions are getting reconsidered by the federal court or something of that sort?
Okay, so I think there are a few questions that you're asking here. First of all, does IRCC keep like a performance log in terms of Officer X is constantly being challenged in federal court? Yeah. I don't think they do it as a matter of practice. I think there's a culture where overall there's a lack of accountability in the IRCC, because we've seen some tremendously poor decisions that we then negotiate settlements with the DOJ. Sometimes, frankly, I argue that allowing a decision like that to stand will just entrench a culture of absenteeism, of just completely being disconnected from what is happening in front of you on the sheet of paper. So I don't think IRCC does that as a matter of course. Now, you may ask somebody like Stephen Mearns, who does a lot of ATIP requests and so on, maybe he will have some additional information on that. And by the way, it's great to be a part of a bar where people are trying to do things to help others, to sort of hold RCC accountable, to bring some transparency. Yeah. With respect to applications that are sent back, so a couple of things that are important here. If we negotiate a settlement with the Department of Justice, in some cases, so a settlement without a hearing, in some cases, we try to get directions to the next officer. Otherwise, let's say I know I have a file that's problematic and it will just keep being rejected. So I try to negotiate certain directions with respect to humanitarian compassion factors, many other factors, whatever. Number one. If I'm not able to do so, even if it goes back, right, without any directions, in my submissions, I will address the key issues that I've raised in my memorandum of argument. And I will try to point to the fact that the approach here was unreasonable, or there was a misapprehension of evidence. And I'll try to create a guideline for the next visa officer. So it's not just, it came back. Why did it come back? Because the previous visa officer misapprehended the ties to the country, didn't understand the employment prospects, whatever it is, right? Sure. If a court comments on a file, quite important. Let's say you go to court because people say, Lev, what's the point of a judicial review? It just goes back and they will reject it again. If a judge comments on certain aspects of your case, factual findings, legal findings, etc., the next visa officer is bound by that, right? Very important. In some cases, I will say directions or I'm going to court because I'm not going to be bounced around between officers on a tough case and so on. So if you're successful at federal court and the judge comments on certain aspects, the next visa officer is bound by it. Even if there's no elaborate decision, the visa office understands that the mistake was made. In my view, cases that go back from GR, more or less standard cases, have a very high chance of being approved. In some cases, you may have to go to federal court to make yourself to Canada as a student or whatever else. The unfortunate reality.
Okay. Because it's an understanding, right? For a lot of people who file their study permit applications, their visit visa applications, in a lot of cases, and now that we understand with the Chinook system being used, that a lot of these applications probably are refused with some sort of a bias in the system. But for most people, they think that the chance is lost the minute they get a refusal, the minute they get an application being rejected. Sometimes they don't even ask for a GCMS notes to understand the real reason, and they give up after, let's say, once or twice they have tried. For a lot of you, order the GCMS notes, understand the visa officer's refusals, and if you think those refusals do not make sense, then trust me, you may have a good chance to get a judicial review and probably get your application reconsidered, or basically you might have a chance to get an approval after that. So consult a professional with that. But I do have a question from the audience for you before we...
Kubeir, just a quick second. I don't know how much time we have, but it's important to know.
We have plenty of time. Don't worry about the time.
On that, you're absolutely right. But what I will say is, and maybe you can explain the Chinook to me as well, because I don't fully understand what they're doing. But if you're thinking about the judicial review, so remember how we talked about the template for the notice of application, which indicates no reasons exist? Sometimes what we do is we tell the clients, hey, you want to get those reasons. So two options. You file an ATIP request. Sorry, I'm just seeing.
No, don't worry about it. That is just that is just your client who's sort of...
Yeah, it was Staff. So it's one of our former clients. Thank you, Staff. It was a pleasure to help you. So if you're thinking about challenging a decision, there are two ways you can get your GCMS notes, the reasons, right? If you file a notice of application in the federal court indicating no reasons exist, the court will then direct IRCC to produce the reasons. And then from the time they're produced, you have 30 days to either perfect, means to take your case to the next stage, or in some cases, you may say, hey, no, I'm not interested. The application was actually quite weak and so on. So do not give up your procedural right just by ordering GCMS notes, which may take 60 days, 90 days, whatever. If you're thinking about the federal court, if you're thinking, hey, something's wrong here, you can file a notice of application, get the reasons. If you don't want to continue, you don't have to. At the very least, you'll protect that procedural right? So that's just an important sort of
that's very important. That's very important, because nowadays GCMS notes can take more than 60 days to come through. And
why do we have to? No, but I'm serious, because as immigration lawyers and consultants, because I've been doing it for 10 years, right? Other people have been doing it for longer, and it's as if they have accepted this parallel universe where things just don't kind of make sense. It's okay for an application from an investor to be pending for 4 years, who's like, that's fine. GCMS notes taking 90 days. That's like, why don't we have a system whereby somebody can see right away where's their application? Why do they need to find out, for example, about review required from GCMS notes? Like, or what are the concerns, right?
I have news. I have some update for you on that. Probably you don't know about this yet, but IRCC is exploring a pilot experimental project whereby for temporary residence applications, they will indeed share the refusal notes along with the refusal letter. I thought that was incredible. That has to be the biggest achievement for anybody who basically championed for that cause from IRCC, because IRCC is actually trying to do that. So it's a pilot project. I know of a couple of practitioners who did receive the notes of the visa refusal along with the refusal letter. So I know a few practitioners have been getting it, but by and large, people haven't started getting it. But that's the pilot project, and I'm
hoping they were considering that. I was making a broader point, but think about it. This is an achievement.
It is, right? See how happy I am about this.
No, it's fantastic. June 2022, we've achieved something that is as obvious as sort of, I don't know, daylight or something. Like, hey, why force a person to order this? Go for a judicial review. Or why do you need to have a PhD to understand GCMS notes, right? You have to track, like, you have to sit there and pull things out. And sometimes there's no reason for the concern. Anyhow, I digress, but I mean, it's great.
What is my pet peeve with IRCC in terms of how much time they take to do something? And my biggest pet peeve is the PR cards, right? You are a permanent resident. You come to the port of entry. You have now been confirmed as a permanent resident. What the hell stops them from installing a printer which can print a plastic PR card and say, hey, this is your PR card. Off you go. You can go in and out of the country. Why does it take 2 months, 3 months, 4 months, 5 months, 6 months to get a PR card delivered to their mail address? It is the most simplest of technologies.
What do you think? What do you think is the reason? What comes to mind, Kubeir?
Well, the only thing that comes to my mind is that some people have to keep their jobs. That's all. That's the only thing that comes to my mind. Because I can't understand what is the reason why the PR cards have to be processed in a different office elsewhere, and then it takes 4, 5, 6 months to be delivered to an individual.
I think their government inefficiency. If I had to sort of create a reason that is perhaps speculative, but maybe they want people staying for a bit. I'm not sure, but you know how some people land and then they have to. But that doesn't make sense, that explanation, because
because as an individual, you still have the right to come back into the country, even if you have a COPR. You could come through the land border.
I agree. So,
PR. Imagine PRTD, right? You have to apply for permanent resident travel document. You can take that entire section away, and you not have too much of work to do, because people have PR cards to go in and out of the country. You by giving them permanent residence, you're not making them bonded slaves that you have to stay in the country. You cannot leave the country. You can't do that, right?
I agree. Just
a pet peeve.
Don't make sense. Some of this. Anyway.
Sorry, that's your client giving you that kudos. So great job there, Lev. Okay, here's a question for you. Says Faith, you said paper-based applications take more time to get approval after mandamus. Please, can you explain why?
Okay. So what I'm saying here, there are sort of generalities that I've observed. I'm not saying that, like, if I would have done like 1,000 mandamuses, maybe my data set would be better. But what I'm noticing is that in some cases, paper-based applications take longer to move after a mandamus. Why? I think maybe some of the sort of system inefficiencies whereby there's even a bigger backlog there, and maybe it takes them longer to actually sort of action them and so on. I'm not sure. One of the arguments I make when I'm dealing with paper-based applications, because they're going to raise COVID, and I anticipate it. And I say this is akin to a steam train, right? If you created a steam train, why are we mailing applications in 2020? And so on. So why are they taking longer? Unfortunately, I don't have a good explanation for you. I think it has to do with operational inefficiencies.
Okay. All right.
Why are citizenship files being quicker? Maybe it's just because it's easier to approve. Maybe the office is more digitized and more organized and so on. So anyhow.
That's another one for you. What is the implication of letter of no reason response by IRCC to notice of
so this is a very common confusion, and I guess I'm maybe not doing a great job explaining this whole no reason letter. So again, let's just compare. So just bear with me. This is
go for it. Go for it. It's a question.
Why does the no reasons letter exist to begin with? Just because we're using a template that forces us to indicate whether reasons have been received or have not been received. This template is ill-suited for a mandamus proceeding, which presupposes that no reasons have received, no decision has been made. Now, we offer a couple of procedural steps. One of them eliminates the no reasons letter, but requires a full payment up front, and we'll get into that. So what is a no reasons letter? By using this template, let's say we check the box which says no reasons exist. Kubeir, you know this. The register will then order IRCC to produce the reasons, so to speak, for this file, which normally means the rejection reasons. In this case, because the application is pending, IRCC will produce a letter saying, this permanent residency application is still pending, therefore no reasons exist. You have 30 days from the receipt of that letter to perfect. That is all. The no reasons thing is a standard response. There's nothing to worry about. It doesn't mean that IRCC is not going to process your application and so on. I have clients, messaging me in the middle of the night. Are they saying they're not going to process the application? No, it's a standard step. We can eliminate this step if you proceed with the expedited option. This is a technical question, so I don't want to spend.
Absolutely technical question, and I thought, okay, we should take it anyways, because obviously there are some audience out there who understand this better. So for their reference, all right, there's another one. Can a mandamus be filed on the basis of ROC support only working on India files? Cure, I'm not sure what that stands for. An applicant has recently received GCMS notes where an officer mentioned that application is in queue indefinitely.
Indefinitely, I like that. So can you just break this down? Can a mandamus be on the basis of ROC support?
ROC basically is for Rapid Response Operations Center, which is now taking on applications which need to be processed faster. But at the end of the day, I think it's still an application which is stuck in the processing queue.
I mean, you can mandamus. So here's a story about IRCC. We have a client from New Zealand was coming in. He's a CEO of a mining company. Applied for the ETA on his own. Fine, you don't need a lawyer for an ETA. It took them 7 or 8 days to issue the ETA. He missed his flight, for example, right? You can ETA mandamuses. You can mandamus an ETA if you want to. You can mandamus anything. What you have to keep in mind is roughly the test. Do you meet the requirements of the program? Is the delay unreasonable? Have you made a prior demand for performance? Are there issues with your application that may lead to a refusal? Keep those in mind, and if those are okay, you can proceed and file.
Well, okay, all right. There's another one for you. Abiola says, "Thank you, Lev. I got mine in 2 days." So you've been doing good job out there, Lev. You know, there are people who are now saying that you managed to get it for them in 2 days.
Well, frankly, as much as I enjoy it, I wish I was doing something else, because I've also taken on a lot of this pain, and my fiance has to hear about IRCC every day, and this outrageous things happen, and so.
Okay, there's another one. Will request your expertise on my case. I have applied for the federal consent in November 2017 after 1.5 years of getting the Quebec selection certificate. Status says that it is 100% complete since December 21. Still no revert.
Yeah, so anything Quebec related, Quebec. I don't practice in Quebec. I don't know if you do, but in my view, their system is in some way even worse. Yes, you can file a mandamus. In some cases, what we'll do, and I cannot do this in every case, so I'm telling people right away. But in some cases, I will file a notice of application and reach out to the DOJ, to the Department of Justice lawyer. Because one of the things that happens with a mandamus and the judicial review, a lawyer is typically assigned either right away or quicker than normal judicial review. And I'll say, hey, can you speak to your client? Like, this is silly. The application is approved. And sometimes we resolve it that way without perfection. Now, I'll repeat this. I cannot do this in every case. So do not ask me to do it in every case. The DOJ is not our pen pal. We're in litigation. I will only do it when appropriate. If I start pestering in every case, they're not going to like me. I'm going to be less effective and so on. But in some cases, we do this. Like, we have recently had a Russian file, Canadian experience class pending for like 33 months. Approval in file says approved, etc. We filed the mandamus, no response. We perfect, no response. DOJ writes to us saying we're not objecting to the leave application. I'm like, because I kept thinking there's going to be movement. I write to the DOJ. I know the lawyer, great lawyer. Within a couple of days, we resolve it. He finally gets his passport request and so on. So sometimes we solve things this way. Quebec, unfortunately, I think is quite poorly managed. Kubeir, do you work with Quebec files?
No, I'm not authorized or licensed to work in Quebec, and therefore I don't handle those applications. I do refer them to some of my other colleagues who are licensed to work in Quebec, not for me.
Good.
All right, there's another one. After filing an application for leave and judicial review, how long does it take for the decision?
Okay, so we've talked about this, but very briefly. The way the process is generally supposed to work with the writ of mandamus, you file your notice of application, you perfect, DOJ response, you do a short reply, it goes to the leave stage. If leave is granted, the court will hear your case. It will then go to a hearing. If the judge agrees that you deserve a mandamus, he will issue an order directing RCC to process the application in a certain number of days. That's how it should work. What happens in practice, again, based on our experience, is within 30 to 60 days, on average, normal files see a decision being rendered. Now, normal files, because everybody thinks their file is normal. If you've been banned for misrepresentation, it's probably going to take longer. If you filed adoption documents which are not compliant, it's probably going to take longer. If you've previously been rejected a visa, unfortunately, it may take longer. If your employer is under investigation, it will take longer. If the provincial body which issued your certificate has questions and has asked IRCC to put it on hold, it will take longer. If you owe child support and a spousal, program meeting the questions with respect to eligibility, it will take long. Because sometimes clients are like, oh, Lev, you said 60 days. But I've also explained that in some cases it may take longer, right? Like at the end of the day, it's what you come to me with. I can tell you, generally speaking, citizenship pretty fast. Spousal, you're likely going to perfect, etc. Anyway, I think that answers that.
All right, some compliments for you there. Lev seems like a great and a very knowledgeable lawyer. There you go. Well done, Lev. Okay, let's try and wrap this up because I know it's a bit we've already crossed 1 hour, but I want to pick your brain on the review required. So there are a lot of applications. If you order the GCMS notes, you will see the note review required. What does it mean? I mean, I know it, but for my audience, please, what does it mean? What do you mean by review required, and what can you do about it? Does the review required applications, should they also be taken to the DOJ for writ of mandamus?
Yeah, so to the court, to the writ of mandamus. But a couple of points. So review required means that your file should be reviewed by a senior officer. I'm generally explaining it, by an officer with respect to some issue. So some issue requires a review. Now, unfortunately, without ordering GCMS notes, you may not know that your file is A, review required, and B, what is the review required with respect to. Another point is review required files, from our experience, take longer. Mismanagement, maybe they forget about them. It's almost like you have 50 simple files, you can approve them, and this file, review required. So they generally take longer to approve. And I think as the backlog clears, some of those review required files, some citizenship files, maybe some spousals, will be the majority of the mandamus files. The regular FSW, CC, P&P will probably go away. So review required, typically in my view, is with respect to a few things. If you had a previous rejection, you're likely going to end up in review required. Kubeir, you can correct me here if I'm wrong. I don't know if there's anything statutorily that says that the file has to go in review required if there's a previous rejection or a statutory question. But I typically see this. I know, what is your view on that point?
Well, in my view, as far as review required is concerned, is that the review required is usually flagged by the program assistant or a program analyst at the very initial stages when they are doing the A11.2 checks. And so basically, a program analyst or a program assistant is not authorized to make a decision on the application. But if they find anything in the application which is not by the book, they will then flag it as review required for the visa officer to take a look at it and make a decision. That decision could be refusal. That decision could be, go ahead with it and approve it anyways. It could be asked for additional documents. It could be a procedural fairness. It could be anything. But the visa officer has to make the decision based on how serious that flag for the review would be.
But I'm asking you with respect to, so I'll go back to review required. I was asking, so in my view, review required typically is with respect to a few things: proof of funds, employment records, statutory questions, and maybe some sort of an admissibility concern that may or may not tie into statutory questions. We've seen weird esoteric things like adoption certificates and so on not being proper, but those are the major areas for review required. My question to you, and I don't know if you know the answer for this, is with respect to, let's say, a previous refusal. Let's say you've previously been refused a visa to Canada. I see those files in review required. I don't know if there's something in the manual which says previous refusal equals review required, whether correlation means causation, and so on. Because some of those review required files seem fairly straightforward.
So previous refusals could be for any number of reasons. If, again, the program assistant cannot immediately identify the reason, and obviously, in some cases, when people answer the question saying, but you refused the visa, and you say, yes, I was refused a visa for, they will just say, I was refused a visa so-and-so country in so-and-so year. No reasons are mentioned, no details are mentioned. Then the program assistant, who may not have access to the detailed records, would then review it or flag it for review required, where the visa officer has to assess the review required in the sense like, why was the visa refused? Is there any inadmissibility concern? Is there a misrep concern? Is there some conflicting information in the previous application versus this? Do the FOSS records indicate anything of concern? Those will then become a review required where more
that makes sense. So jumping back to review required and mandamuses. So if you see a review required note on your file, try to understand what is it with respect to. We generally recommend to clients address this preemptively. Proof of funds, currency fluctuations, provide new bank statements, have some margin there, provide a bank letter, send it off. Maybe you've submitted funds that were like in the GIC or something like that. That's not going to comply with the requirements. So address them preemptively. Employment, very important. Failure to match the leading statement of the NOC. Officers, unfortunately, will just reject your application. Why don't they give people the opportunity to respond? I don't know, just creates litigation, waste time. But that is an issue that we occasionally see. Address this preemptively. Do not file a mandamus. Do this as soon as possible.
Let me add that there is a difference between the proof of funds review required and a occupational review required. Occupational review required comes under assessment under section A11.2, whereby the officer will just establish and validate the work experience based on the knock. It's in the ministerial instructions as well. For proof of funds, because it comes under the regulations as well, it's a very categorically mentioned that if the proof of funds are not as adequately required, then a PFL must be generated. So there has to be a procedural fairness if they have to refuse an application for proof of funds, but that is not necessarily so for occupational documents because that is the requirement. So yeah, it's totally different.
Very important point. On certain issues, RCC will not give you an opportunity to respond, which I think is wrong, because I've seen cases where there were maybe a question with respect to the employment letter, but the employment letter was largely compliant. The officer rejects it. It creates a judicial review file, a reconsideration, more work. So I think there's an issue there. But in general, review required files are unfortunately more likely to be stuck. Sometimes for no good reason. We had a client who's now become a friend. There was a question with respect to his relative in Canada. And he was just waiting, and he ended up filing a mandamus and so on. But some of them are for silly reasons, if you will.
All right. Could you please let people know your fee charges for your services associated?
Sure. So we generally have a standard fee rate. Now, if your case is more complex, we may charge more and so on. But generally, there are two approaches. One approach is file the notice of application indicating that no reasons exist, wait for the no reasons letter, get the no reasons letter. If the application is not approved, proceed to perfection and so on. So option number one. The benefit here is you're paying for each stage: notice of application, then perfection. If we don't end up perfecting, or we don't complete the record, but we retain to perfect, we'll convert it into an hourly rate, give you the money back. Happens quite often, like give you whatever we've not used back. So that is step by step. The second option is proceed to perfection after filing the notice of application. Now, the complete perfection fee, so notice of application plus perfection, is $42.50. $50 go to the court. So 4,250 Canadian dollars for the initial stage. A part of it is for the notice of application. A part of it is for the perfection. So I don't want to go into this breakdown in terms of how things work with respect to the notice of application versus perfection, because I'd rather just send that information to clients. But you're roughly looking at $42.50 for the notice of application plus perfection. If it's just the notice of application and you're successful, you don't have to go to perfection. We charge about $1,600. So that's what we charge. So we break it down that way. I think it creates more work for us doing it step by step. I think many other lawyers just say, hey, pay me the whole thing. And my team certainly doesn't love me for this because it creates more work. We have to sort of sometimes ask clients, do they want to proceed, etc. But we now say in the retainer agreement, you have to proceed if it's not approved. So in total for notice of application perfection, you're looking at $42.50. However, if your file is approved after stage one, just the notice of application is about 1,600 Canadian dollars. Taxes are payable by those in Canada. If you're outside Canada, you don't pay those. Current rates, inflation is here. Their price pressure is on. I'm giving you current rates.
Okay, all right, great, guys. If you are looking to sort of talk to Lev and sort of retain him, then that's the email address. Please do feel free to drop him an email, and he, I'm sure, will be most happy to give you more information about his services.
I will just maybe share so that people know, where to go. I'll share our, the purpose here is like if you have litigation, if you need litigation help, atimmigrationlaw.com, exactly. Abramovich Tchern is the name of the firm. We're downtown Toronto. If you need help, we're here to help. And I have to say, I really enjoyed this. This was a great conversation.
But I have two more questions for you before I let you go. I know we have run out of time already, but I'm just going to hold you back for just two more questions. Please bear with me. What if, let's say, you've submitted your PR application, you've submitted your express entry application, it does get refused, it does get rejected. Hi, are you still there?
Yeah, I'm here. You disappeared for a second. The volume disappeared.
I lost you. Not sure I can hear you.
Hello? Can you hear me? One sec, Kubeir. One sec.
Okay, I got it. All right, it's working fine. And thank you. Sorry, I'm sure something went wrong here on my side. Go ahead. So, what should a person do if the application gets rejected or refused?
Okay, so if the application gets rejected, it's important to understand why it was rejected and so on. Generally, if there's a reason, if there's something to challenge there, right, then what we recommend doing is a couple of things. There's an informal process which is called reconsideration. What we recommend doing is filing a reconsideration request while at the same time seeking to challenge the decision in federal court. Why? Because you only have a certain amount of time to challenge that decision. So if you just wait for the reconsideration, the answer may come, it may not come, it may take 60 days, 90 days, 3 months, etc. And by this point, you've lost your right to challenge that decision. If the decision is made on an application that is outside of Canada, you have 60 days to challenge that decision. So we recommend starting judicial review proceedings at the federal court. At the same time, if appropriate, and we think in most cases it is, asking for reconsideration. If the reason is obvious, we'll try to negotiate a settlement with the Department of Justice, so without a hearing. And by the way, I have to give a lot of credit to the Department of Justice. I think they're trying to balance pragmatism versus protecting, or not protecting, versus representing IRCC, if you will. We are often able to negotiate settlements on consent. We generally, like their pragmatic approach to settlement, etc. They didn't build a system. They are not responsible for the delays. They're simply acting for IRCC. But in any event, we recommend doing a reconsideration at the same time challenging it. If the decision is, clearly erroneous, we recommend, reaching out to the Department of Justice, trying to settle it on consent. We've seen some unreasonable decisions, and I think it's so unfair when you get an unreasonable decision having waited for 2 years, 2.5 years, etc. I think the duty of procedural fairness is heightened when there are delays, when there are effects, right? How hard is it to write to the applicant, say, your letter of employment, doesn't, I have some questions. Can you clarify this point, right? The person will then come back maybe with a new letter. He'll be able to immigrate, as opposed to having to hire a lawyer, going through this stress and so on. So anyhow, I digress, but that's what we recommend on rejections. Yeah.
Okay. Then what is coming versus what we would like to see? What do you think about the changes?
Yeah.
What the changes that we are expecting?
You can probably tell me what is coming. I think so. I'm mostly focused on litigation. I'll tell you briefly what I would like to see, and we can go back and forth. I don't see the reason for this heavily. RCC very heavily relies on consular posts. So if Accra, for example, closes down, they have no computers, applications, are not processed, and so on. I don't see a reason for not having a centralized system here in Canada, just like every other institutions, where applications come in. They're obviously, there's some sort of an electronic management system. You maybe use AI to appraise applicants of issues quickly, so you triage them and so on, but don't use AI to adjudicate or to pre-write decisions. So some sort of a centralized system. I think a separate stream for students, they're talking about that, right?
Yeah.
I think it makes sense. People are paying a lot of money to study here. Why should they be subjected to the same rules? And Express Entry changed that fundamentally, right? Before Express Entry, would just submit CCs and so on. I think transparency, accountability, some sort of a live portal where, for example, if a review required is there, the applicant can see the concern, address it without having to order GCMS notes. Those are some things that come to mind. I know that what's coming is the Express Entry economics sort of selection by no code. Yeah. I don't have a problem with that in principle, but the way it's being done is essentially remedied through ministerial instructions. And how is this related to the rule of law, democracy, a parliamentary system, etc.? Some of my thoughts, I know you probably have more than me to say about.
No, well, I mean, if I get started, trust me, we'll be here the whole evening and the whole night. So I don't want to do that. I mean, for me, I think the only thing I would like to see, and that probably would hit the nail on the head, is that I would like IRCC. It's a wish, right? I would like IRCC to be more compassionate. Instead of treating applications as file number, I just hope and pray and wish that they start seeing the files as people, because those are not just file numbers. There are people behind those individual file numbers. Those people have futures, they have children, they have everything at stake in some cases over there. I just hope for a bit more compassion from their side when they do refuse applications. As you said earlier, if they can only give a chance to people to at least explain versus just outright throwing that application out of the window, because in most cases, people may not have another chance and they might have waited for months and years to trying to get to the whole process, appeared for IELTS so many times, probably waited for the draw, may have gotten lucky with the draw and got their invitation. Now they have no chance. So yeah, that is something which I would really like to see. But as I said, it's a wish list. I mean, the way IRCC operates is so robotic in most cases that would be my wish list if at all that happens. All right, so just
let me just say that I think that is a fantastic point, that I think that the dehumanization of the system, whereby it is a file number, there's very little concern with respect to the individual circumstances of that client. I think you bring a fantastic point. In this technological, technocratic world, we all lose connection with each other, but this is about families. This is about immigrants. The IRPA objectives are there, not just in terms of statistics, but enriching our culture, integrating people, in part making them feel welcome, having that connection, like you say. I think that's a fantastic point.
All right, before I let you go, I have just one last question. And I know people are getting tired of me asking that last question, but when do I get a chance of having such a revered individual like yourself on my channel? So the last one, and obviously this is just for the same subject of the mandamus, and that is this: who should not file a mandamus? I know we've been talking about the conditions and the criteria and what people can do, should do, in terms of mandamus application. But then before people start jumping onto the bandwagon and obviously go to, if not you, go to anybody else and start spending money on the consultations and of course the application, who is mandamus not meant for, or who it should not be a resort to? Right.
So a few things come to mind right away. If there are concerns with respect to your application, so for example, employment letters, like you said, there's no provision for a PFL there, right? Say there's a concern with respect to your employment reference letters, you will file a mandamus. Mandamus will likely work. You'll just get a negative decision. So do not file a mandamus if your application is not in a position to be approved. Secondly, people ask me, it's been 6 months, 9 months, etc. So we're pretty aggressive, 15 months onward. We do take on those files. But if everybody starts filing them, ad hoc, there does need to be some unreasonable delay. I understand that it's hard to justify even the 15 months, but we do recommend waiting for a certain period of time. And the rest of it really has to do with meeting program requirements, making sure your application is in a position to be approved. If there's something outstanding from you, if you've done something wrong, maybe, again, like what comes to mind is, we have a file with an adoption case. We didn't prepare the file, but, the adoption documents were not in order. Well, you should probably have put those documents in order prior to filing and so on, and deal with things that way. So it comes back to being able to receive a positive decision. Are you in a position to receive a positive decision? If you are, great. By the way, we have mandamus work permits from India, right? A year for a work permit. We have done spousal, super visa, citizenship, right? So it's not just for the FSW person, right? It's an effective remedy in generally, but do not file it if there are concerns with respect to your application that may lead to rejection. Supplement it, and then allow IRCC some time to attach the documents to the file, and then you're in a much better position to proceed.
Wow. That was an incredible session. Thank you so much. Thank you. I really, really appreciate it, Lev. I mean, you've been.
I appreciate you having me on. It's been fantastic. We should do one in the future.
Sure my audience,
questions.
As I said, I'm sure the audience has greatly benefited from understanding from your and getting in your perspective and your views and your expertise. And I'm sure they will be able to understand what they need to do in their application. So thank you so much. Thank you very much. And I hope you have a wonderful day ahead.
Thank you, Kubeir. Likewise. It's been a pleasure.
You. Well, guys, that was Lev Abramovich, and I will put his contact details down in the description box. Please do feel free to contact him if you think you need his services. He's a great lawyer. You've already seen lots of clients who have been putting their comments and saying that they have been successful with him. So by all means, do that. It was a great session. Thank you so much for joining in. I hope you have found some value in this as well. Do pour in your comments. Let us know how you felt about this. Do also let me know who else do you think we should bring onto our channel for such kind of discussions where you can get better insight into the processes and news and updates. Thank you so much for joining in. I shall see you next time. Take care.